Mic check, 1, 2, 3. Mic check, 1, 2. Good morning, everyone. This is a audio test for our broadcast. Mic check, 1, 2, 3, 4. Good morning, everybody. If I can have your attention just shortly. As a kind reminder to those in the room, if you are registered to speak today, please make sure that the yellow light is on the microphone so we can hear you loud and clear. And also, please make sure to mute the microphone before you leave the podium, as I'm about to do right now. Thank you.
Good morning. This meeting of the Texas Commission on Environmental Quality is called to order. The time is 9:30 a.m. Before we get started, we have a retirement to celebrate. All right, is Ashley Forbes here? Come on up, Ashley. Oh, this one stings. Yeah. Ashley Forbes has over 27 years of state public service. Get over there. She began her career at TCEQ in 1999. She's worked to protect public health and natural resources throughout her esteemed career and has served in many leadership roles at TCEQ, including leading the development of regulations, controlling industrial point source emissions for ozone reduction, overseeing the remediation of contaminated soil and groundwater sites throughout Texas, and directing the work of health physicists, engineers, geoscientists, and other environmental professionals in the Radioactive Materials Division. She has led the Radioactive Materials Division as Deputy Director since 2018. The Radioactive Materials Division license activities associated with storing, processing, and disposing of radioactive waste and activities associated with uranium recovery, as well as the permitting, registration, and authorization of all the wells in the underground ejection control program. TCEQ and the state of Texas are better for her dedicated public service. So that's her bio. That was great. It's all scripted and it's all factual. What it doesn't say is what an amazing human she is and how lucky that this agency has had for 27 years to have her. When they told me you were going to retire, I was like, there's no way she's old enough to retire. It's like, absolutely not. But obviously she's doing something right. But we will miss you so much, and we are just thrilled that you're taking a break, and thank you for everything. Here we go. All right, thank you for indulging us. Good morning and welcome to the September 24th, 2025 meeting of the Texas Commission on Environmental Quality. I'm joined by my colleagues, Katerina Gonzalez and Bobby Janecka, our General Counsel, Mary Smith, and our Public Interest Counsel, Garrett Arthur. For each item that argument or discussion is allowed, we will inform parties and the public of time limits for their discussion. Registration closed at 9:30, but if you'd like to address the commission on a particular item, please either visit our registration table if you're in person or email agenda@tceq.texas.gov with your name, affiliation, and the item you'd like to comment on. We will do our absolute best to accommodate the request. For those making presentations, please wait to begin your presentation until I have asked you to begin speaking. And please check to make sure your line is unmuted before proceeding. All right, Mary, first item.
Item number 1 is the consideration of the proposal for decision and proposed order concerning the petition for the creation of Hayes Commons Municipal Utility District. The parties have been notified that the petitioner will have 8 minutes, protestants collectively will have 8 minutes, and the ED and OPIC will each have 5 minutes of oral argument time. The petitioner should speak first and may reserve a portion of its time for rebuttal as the petitioner bears the burden of proof in this matter. And with that, we'll begin with the petitioner. I believe we have David Tuckfield.
Thank you. I'd like to reserve 5 minutes for my rebuttal, but take 3 minutes now. Thank you, Madam Chairwoman. Am I ready to begin? Thank you. My name is David Tuckfield. I represent Hayes Commons Land Investments LP for the creation of Hayes Commons Municipal Utility District. Because of the limited time, I'm going to focus on 3 primary points that the protestants have raised throughout this issue, throughout this case. And that is, the first one is whether water and wastewater service is available from other systems. A lot of time was spent in the contested case hearing talking about whether the city of Austin could provide water service, and certainly it can, but it just has been unwilling to. The applicant or the petitioner went to the city of Austin right from the beginning trying to get water service, couldn't get it. And despite that fact, that and the testimony was that the city said, no, we can't do it, you're outside of our jurisdiction. Despite that fact, the petitioner continued to work with the city of Austin, and in fact, to this day is continuing to work. It's been 3-4 years now that they continue to work with the city of Austin. There's nothing the petitioner would like better than to connect with the city of Austin, but it just has been unable to do so, has been unable to even get on the agendas for the city of Austin to have these negotiations. And part of the reason, and there's testimony to this effect, it's not just me saying this, there's testimony in the contested case hearing. The protestants in this case are trying to stymie the efforts with the city of Austin and trying to keep the city of Austin from giving this petitioner water service. So they come to this case and say, well, you should get water service from the city of Austin. Then they go over to the city of Austin and tell them, don't give them water service. And so that's what's happening here. And so the question of whether water service is available, well, it might be theoretically available, but it's not available because they can't, the petitioner simply can't get it. The second issue that's been discussed a lot is the effect of water quality. The petitioner has submitted an application for a TLAP permit, and in fact, you'll see that the hearing requests are coming up next month on your agenda. So the petitioner is going to go through the TLAP process, and we'll see if we get the TLAP permit or not. But that's a separate process. A lot of the time at the contested case hearing in this case was discussing whether the TLAP was a good thing or not, whether there was going to be water quality issues from the TLAP permit or not. The ALJ appropriately determined that this proceeding addresses a petition for mud creation, not the TLAP application, which is a subject of its own review and hearing process. So, and the ALJ noted that mud itself could exist without the TLAP.
That's 3 minutes.
Okay, and I'll reserve the rest of it for later. Thanks.
Thank you, Mr. Tuckfield. Protestants?
Good morning. Victoria Rose on behalf of the Aligned Protestants in this matter, Save Our Springs Alliance, Philip Brisky, Darlene and Michael Starr, and Lydia and Antonio Valdez. You are here today to consider the petition to create the Hayes Commons MUD. While the creation of a MUD is normally a weighty decision that considers the creation of a powerful political subdivision of the state of Texas, your decision today carries additional weight due to the district's location in Hayes County over the Edwards Aquifer Recharge Zone in an area with a ton of sensitive karst features. And the Edwards Aquifer, of course, is a water source that many depend on, and it's at risk here. Luckily, the Texas legislature had the foresight to create a safeguard against the creation of MUDs in Chapter 54 of the Texas Water Code, and it's designed to protect Texans by requiring TCEQ to consider the unreasonable impacts of a proposed MUD and to require the applicant to meet an evidentiary burden on each of the issues considered. But this safeguard only works when the plain language requirements of Chapter 54 are applied and the evidence in the record is carefully considered. Unfortunately, the plain language of Chapter 54 was not applied in the PFD in this matter, and the applicant was found to have met its burden on issues without providing relevant evidence. This morning, I'll focus on three main issues that best highlight the problems with the PFD with water quality, groundwater, and reasonableness of costs. So starting with water quality, Chapter 54 requires TCEQ to consider whether the district, its system, and subsequent development within the district will have an unreasonable effect on water quality. However, the PFD refused to analyze the effects of the proposed district on water quality, only mentioning water quality in reference to the proposed district's wastewater disposal plans and deferring consideration of the issue to a future proceeding. Such an approach is not permitted by Chapter 54. The statute requires that TCEQ consider the effects on water quality now, not later. And given the evidence in the record, the PFD's approach of ignoring the mandates of the statute is dangerous. Testimony from the hearing showed that the operation of TLAP permits over the Edwards Aquifer Recharge Zone, like the permit sought by the developer, was tied to a series of pathogenic outbreaks in the late 80s and 90s before the practice of land applying treated municipal sewage was largely discontinued over the Edwards Aquifer Recharge Zone. Testimony also explained that the land encompassed by the district is extremely sensitive to pollution due to the many karst features and lack of natural filtering. Any pollutants that enter the groundwater in the area of the proposed district will quickly show up in nearby wells and Barton Springs. OPIC's closing arguments in this matter summed up the issue succinctly, writing, "Concerns about potential long-term effects on regional water quality and public health risks associated with wastewater disposal in such a sensitive recharge area cannot be overlooked during the district creation proceedings or deferred to a separate water quality permit process at a later stage," end quote. TCEQ is required to consider these effects now, and the applicant was required to provide evidence of the effects. So far, both have failed to do so. Moving to groundwater. Chapter 54 also requires TCEQ to consider whether the district, its systems, and subsequent development will have an unreasonable effect on groundwater levels within the region and the recharge capability of a groundwater source. The ALJ declined to analyze whether the district's plans to provide groundwater within the district from the lower Trinity Aquifer, despite clear direction from the Water Code that such considerations must be made now. Since the applicant failed to provide any evidence that the groundwater pumping proposed in the petition itself would not unreasonably impact groundwater levels, the applicant is lucky that the PFD smoothly sweeps this factor under the rug in violation of the statute. Impervious cover in the district is another issue that will impact groundwater. Testimony shows that increased impervious cover will decrease recharge of the aquifer, but no evidence shows that the proposed increase in impervious cover within the district would not have an unreasonable impact on groundwater recharge. In fact, the applicant provided testimony that its plans to include impervious cover higher than what is allowed under City of Austin impervious covers limits that were designed to protect the Edwards Aquifer from degradation. The applicant bears the burden of proof for every issue in this matter to demonstrate by a preponderance of the evidence that the proposed district will not cause an unreasonable effect, and once again, the applicant failed to do so. Finally, Chapter 54 requires TCEQ to consider the reasonableness of projected construction costs. We heard testimony from the applicant's witness that if the number of lots in the development plan for the district were to decrease, the cost per lot would significantly increase, and a new estimate of cost would be needed. We also heard testimony that the cost estimates for the district in the petition were based on a development plan with 258 lots that would be about 0.339 acres each. The problem with that arises from the Hays County development regulations, which require a minimum lot size of 0.75 acres for homes that are served, like the ones that will be in the district, by a public groundwater system and a TCEQ permitted public water system within the Edwards Aquifer Recharge Zone. Further testimony showed that Hays County has rejected the applicant's subdivision plan and that the development plan precludes the applicant from getting around Hays County's regulations by simply saying it will develop the lots as condominiums. Costs cannot be reasonable for a proposed district if they are based on an impossible plan. They might be reasonable for some other development somewhere else in another proposed district, but for the Hays Commons MUD in Hays County, Texas, they're simply not. The PFD states that this is not a problem because it can be expected that the development will change, and since the development will change, the projected costs will be reasonable at some point in the future. But that contradicts the rule articulated by the PFD on the page before that. According to the ALJ, the reasonableness of costs must be assessed based on the information provided in the petition on the date the petition is submitted. But that's not what the ALJ did here. Instead, the PFD gave the applicant a free pass on this issue because in the PFD's estimation, the plans could change from what was in the petition and the cost could end up being reasonable. But based on the petition, the day it was filed, and the applicant's own testimony, the projected costs are unreasonable because they're based on an impossible plan, and completely new estimates are needed to assess whether or not projected costs are reasonable with larger lot sizes. To conclude quickly, the PFD is inconsistent and ignores the plain language of Chapter 54 of the Water Code. I hope today that you will apply the plain language of the statute to the facts in this case to deny the petition. Thank you.
Thank you, Ms. Rose. ED staff?
Good morning, Chairwoman, Commissioners, General Counsel, and Office of Public Interest Counsel. I'm Kayla Murray, and I'm an attorney in the Environmental Law Division representing the Executive Director. With me today is Justin Tack, Manager of the District Section. The ED recommends the Commission adopt the ALJ's proposed order and create the Hays Commons MUD. In the proposal for decision, the ALJ concluded the applicant met its burden of proving the district's creation meets all applicable statutory and regulatory requirements. In response to the concern regarding the proposed wastewater disposal within the Edwards Aquifer Recharge Zone, as noted in the PFD, this proceeding addresses the petition for a MUD creation, not the TLAP application, which is subject to its own review and hearing process. This MUD creation hearing is not the appropriate forum to evaluate the merits of the TLAP. The ED agrees with the ALJ's position on this issue. The ED recommends that the Commission grant the petition and create the district. Thank you, and we are available for questions.
Thank you very much. OPIC?
Good morning, Chairwoman, Commissioners, General Counsel, and the Executive Director's attorney and staff. For the record, I'm Pranjal Mehta with the Office of Public Interest Counsel. OPIC participated in the hearing and carefully evaluated the evidence and arguments. Based on that review, OPIC concluded that the petitioner has not met its burden to show that the district and its subsequent development will not have an unreasonable effect on water quality. The record indicates that almost 90% of the district's area lies within the environmentally sensitive Edwards Aquifer Recharge Zone. OPIC agrees that creating the district does not itself authorize construction of a wastewater system. When that time occurs, any system must comply with DCEQ's permitting requirements. However, the record also contains expert testimony showing that this project could create significant risks of water quality degradation and possible contamination of public water supplies. Given the strength of this evidence, OPIC finds this to be a unique situation in which the protestants' concerns are relevant to water quality consideration under Texas Water Code Section 54.021, subsection B3F. As stated in OPIC's closing brief, concerns about potential long-term impacts to regional water quality and public health cannot be overlooked at this stage during the district creation proceedings, or they cannot simply be deferred to a later permit process. For these reasons, OPIC cannot find that the petitioner has carried its burden with respect to this issue. We respectfully disagree with the ALJ's recommendation and recommend denial of the petition. Thank you, and I'm happy to answer any questions.
Thank you very much. Mr. Tuckfield, you have 4 minutes and 58 seconds left.
Thank you. Yes, let's talk about the three main issues that SOS brought up. First of all, the water quality. I've already talked about that a little bit, the TLAP permit. And the protestants noted that the ALJ talked a lot about the TLAP permit and suggested that there was no other evidence about water quality. But in fact, there was evidence in the record about water quality. We provided evidence on runoff, stormwater, and water quality in general, and even had a geologist talk about the groundwater and all the connections that could be made. So the reason the ALJ spent a lot of time talking about the TLAP permit is because that's 95% of the evidence that the protestants put on. And so this hearing turned into a TLAP permit proceeding when it really just wasn't. And the fact is, you have to separate those two proceedings. Otherwise, why would you even have the TLAP permit proceeding? So there was evidence, and the applicant did provide evidence that addressed water quality. With respect to groundwater levels, the other thing I should note is the protestants talked about the wastewater plant failures in the 1980s and 1990s. But those plants had nothing to do with this plant. I mean, it was technology from 30 years ago. It was issues from a different, there's nothing to tie those failures to what's going on here. And it was just an interesting kind of exercise. As far as groundwater levels go, and that raised the question on the third point that I didn't get to when I first started. The protestants seem to want this body to decide what Hays County is going to approve and not approve, what kind of variances Hays County is going to allow and not allow. So as long as we comply, there's testimony in the record that says that we will comply with the Hays County regulations, and in fact, as far as groundwater pumping goes, we have to comply with the Groundwater Conservation District requirements. Then there's testimony that says the groundwater levels will be fine. And again, we have a hydrogeologist that testified to those facts. But this body shouldn't be deciding what Hays County or the Groundwater Conservation District is going to decide. And so that takes care of the groundwater levels. With respect to construction costs, that also is a question of, they've raised a lot of questions about whether we can comply with the Hays County regulations or whether a variance is allowed. There is testimony in the record from our engineer that talks about alternatives that can be done. They could go with what's, according to the testimony of Mr. Ryan, the engineer in this case, he says we could go with a condominium plat where you still have detached single-family units, but they're all within one master lot, and you could still potentially comply with your regulations. That fight's not over. That's, again, with Hays County. It's not here. Your job is to review the application as it's submitted, as you decided in the Highland Lakes case, and in other cases, it's the application and the plan that you're submitting. If that plan doesn't work with Hays County, then the developer and the petitioner has other problems with another body. But that's for another day and another body. So in sum, there is evidence to support this petition, plenty of evidence, and we can't get derailed by trying to decide what the city of Austin is going to do, what Hays County is going to do, what the Groundwater Conservation District is going to do, and how these different regulatory bodies and what you're going to do in the TLAP proceeding. The question is, does this application satisfy the requirements? And it does. And I appreciate your time, and I'm available for any questions.
Thank you, Mr. Tuckfield. For item number 1, we are considering Hays County Land Investment LP's petition to create Hays Commons Municipal Utility District and authorize road powers. First, regarding the objection to the Commission's consideration of OPIC's closing argument in lieu of exceptions, which erroneously suggests that the Commission is only reviewing the materials Posted online in PFD Matters, I would note that the Commission considers the entirety of the administrative record, including all filings, evidence, and hearing transcripts, in addition to the post-hearing exceptions, when it does make its decision, not just the documents that are posted online. As to the merits of the case, I agree with the ALJ's recommendation to grant the petition and would adopt the ALJ's proposed order with the changes that she recommended in her July 25th, 2025 letter responding to exceptions. I would also make one additional change to the proposed order. In conclusions of law number 13, I will remove the reference to 30 Texas Administrative Code section 293.11 D5J to emphasize that the preliminary engineering report content requirements are not a separate burden from the statutory determination in the Texas Water Code section 54.021. Colleagues?
I agree as to that deletion that you clarified. I also generally want to acknowledge and appreciate OPIC's position in voicing concerns on the water quality impacts, but I don't feel in reviewing the record that there is a basis sufficient for overturning the ALJ. I do note that will presumably create a larger source of pressure on our agency when we're considering those permits, and I think the applicants and the different stakeholders here are aware of that dynamic as our agency sees more of an investment around a need for a permit. Almost ironically, our agency needs to apply closer scrutiny, and so I'm confident that our agency will be reviewing that, but that doesn't connect to this particular matter.
Katarina?
I'm in agreement with the chair.
I move that we adopt the administrative law judge's proposed order as revised by the ALJ's letter regarding exceptions dated July 25th, 2025, and delete the citation to 30 Texas Administrative Code sections 293.11 D5J in conclusion of law 13 to clarify that the regulatory preliminary engineering report content requirements are not a separate burden from the necessary statutory determination.
I second the motion.
All those in favor?
Aye.
Aye. Aye. Thank you. The motion passes. Thank y'all very much. I'll give everyone a second to shuffle.
Item number 2 is the consideration of an application by Buffalo Hills Development LLC for new TIPD's permit number WQ 00162160001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Morning. Item 2 is the application by Buffalo Hills Development LLC for a new TIPD's permit to authorize the discharge of treated domestic wastewater at a daily average flow not to exceed 850,000 gallons per day during the final phase. The Commission received numerous hearing requests and requests for reconsideration from individuals in this matter. Ellis County filed a withdrawal of its hearing request and protest last week. We usually take up the hearing request first, but today I'd like to begin with some of the allegations raised in the request for reconsideration. The request for reconsideration raised some public notice concerns, which OPIC also flagged. The facility and discharge appear to be located in both Johnson and Ellis counties. The NORI and NAPD were not both published in both counties and were published in different newspapers. Neither the RTC nor the ED's response addressed the sufficiency of this approach. Given the uncertainty surrounding the sufficiency of notice, I would recommend granting the request for reconsideration, remanding the matter to the ED, and requesting the ED to evaluate the adequacy of the public notice in this docket. The ED would be free to work with the applicant to require additional notice or request an agenda setting to consider the existing hearing requests and request for reconsideration if the ED believes that the existing notice was sufficient under the Commission's rules. I'll stop here. Bobby? Thoughts?
I appreciate you raising the concerns. I think I share your views.
Also in agreement.
Do I have a motion?
I would move that we move that we grant the requests for reconsideration regarding public notice, that we remand the application to the executive director to evaluate whether additional public notice is necessary and reserve the commission's consideration of all hearing requests pending the executive director's reconsideration of the application.
Second.
All those in favor?
Aye.
Aye. Thank you. Motion passes.
Item number 3 is the consideration of an application by J7 Ready Mix LLC for issuance of air quality standard permit for concrete batch plant, registration number 172856. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Before us, we have a registration application for coverage under the Air Quality Standard Permit for concrete batch plants, which would authorize the construction and operation of a concrete batch plant in Tarrant County. The Commission received many hearing requests and requests for reconsideration. When considering hearing requests for these types of applications, the Commission follows a two-step process. First, we consider whether any of the hearing requesters have met procedural requirements, that they've demonstrated how they may be affected by the proposed authorization in a manner different than the general public. If the Commission finds that any of the hearing requesters meet these requirements, then we determine what relevant and material issues were timely raised. The Commission received timely hearing requests from approximately 105 individuals. I'll begin with my thoughts on effectiveness. To be considered an affected person, a requester must explain how they will be affected by the application in a way that is not common to the members of the general public. The hearing requester must also file both timely comments and a hearing request that identify their personal interests and concerns that they have. The identified concerns must be within the Commission's jurisdiction to address in the authorization. Additionally, for registrations under the Air Quality Standard Permit for concrete batch plants, only those persons actually residing in the permanent residence within 440 yards of the proposed plant may request a hearing as a person who may be affected. Turning to the hearing requestors in this matter, I believe that the hearing requests of Chance Barnett, Nicole Barnett, Chad Brewer, Jessica Brewer, Justin Brewer, Mary Elizabeth Brewster, D. Mike Brewster, Judy Ann Daniel, Mitch Daniel, Chris Davis, Julia Galindo, Loris Phyllis Glasser, Carrie Amanda Grant, Lindsay Lee Hendon, Larry Wayne Hendon II, Brandon Justin Eaglehart, David Gill Maffey, Brandon McElroy, Donna and Harold Montgomery, Sandra Pendergrass, Tommy Pendergrass, Janice Penwarden, Donna Phillips, William Rabowskis, David Smith, Judy Smith, Haley Trammell, Selena Wilson, and Kendall Wyatt should be granted. These requesters live within 440 yards of the proposed facility and raise personal justiciable interests that are affected by the application. Regarding Brian and Lori Edgar, I recommend that we refer their hearing request to SOA for an effectiveness determination. According to the ED's calculations, the Edgars reside approximately 446 yards from the proposed facility. Based on the Google Maps satellite view included in the ED's response, it appears that the corner of the Edgar residence may be within 440 yards. Given this conflicting information and since distance is dispositive in this application, I would refer the Edgars for effectiveness so they can provide evidence demonstrating their exact distance from the proposed facility. Finally, I deny the remain hearing requests because they either live beyond the 440-yard distance limitation, failed to file comments during the comment period, or did not raise any issues in their hearing requests. Bobby?
I see it the same way and capture the same list of affected persons.
Katerina?
I agree.
Moving on to the second part of our analysis on issues, affected persons raised relevant and material issues regarding health and safety, air quality, animals and vegetation, notice requirements, nuisance test, application sufficiency and accuracy, and compliance history. These issues are within our jurisdiction to consider on this matter, so I'd recommend that we send these to SOA. I'd also recommend denying all the requests for reconsideration because they either involve issues that are going to SOA or they don't raise new or relevant material information for the commission to consider. Finally, I'd recommend a 180-day hearing duration. Colleagues,
I'm in agreement.
Same.
do I have a motion?
I move that we grant the hearing requests of Chance Barnett, Nicole Barnett, Chad Brewer, Jessica Brewer, Justin Brewer, Mary Elizabeth Brewster, D. Mike Brewster, Judy Ann Daniel, Mitch Daniel, Chris Davis, Julia Galindo, Laura Phyllis Glasser, Carrie Amanda Grant, Lindsay Lee Hendon, Larry Wayne Hendon II, Bradley Justin Eaglehart, David Gil Maffey, Brandon McElroy, Donna and Harold Montgomery, Sandra Pendergrass, Tommy Pendergrass, Janice Penwarden, Donna Phillips, William Ribinskus, David Smith, Judy Smith, Haley Trammell, Selena Wilson, and Kendall Wyatt. Refer the hearing requests of Brian and Lori Edgar to SOA for an effectiveness determination. Deny the remaining hearing requests and all requests for reconsideration. Refer the matter to SOA for a contested case hearing on the following issues. A, whether the permit will be protective of the health and safety of the requesters and their families, including sensitive subgroups and physical property. B, whether the permit will negatively affect air quality. C, whether the proposed permit will be protective of vegetation, animals, and the environment. D, whether the applicant substantially complied with applicable notice requirements. E, whether the permit will be protective against dust emissions generated from the proposed plant, including nuisance dust emissions. F, whether the application is accurate and substantially complete regarding emissions calculations and the identification of equipment being used on site. And G, whether the application should be denied based on the applicant's compliance history, and specify that the maximum duration of the hearing is 180 days from the preliminary hearing to issuance of the proposal for decision.
Do I have a second?
I second the motion.
All those in favor say aye.
Aye.
Aye. The motion passes. Thank you. Going on to item number 4.
Item number 4 is the consideration of an application by Terrell Timmerman Farms LP for new TIPD's permit number WQ0016229001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Before us, we have an application for a new TIPD's permit that would discharge up to an average flow of 975,000 gallons per day of treated domestic wastewater in its final phase. Again, for these type applications, the Commission considers a two-step analysis. First, we must determine whether a hearing requester is an affected person. Jonah Water Special Utility District, the sole hearing requester, submitted timely hearing requests and comments. Jonah raised concerns with water quality and stated that it provides water service sourced from Lake Granger, surface water, and water wells. However, Lake Granger is located at least 8 miles from the proposed discharge point, and Jonah did not identify other water sources it uses near the discharge point in its filings. Jonah also raised regionalization concerns, but it did not provide information about its current ability to provide wastewater service. After considering the concerns raised and the size of the proposed discharge, I do not believe that Jonah has shown that it has a personal justiciable interest in this application. I've also reviewed the permit information and the ED's RTC, and I am prepared to move forward to issuing the permit. So I'd propose that we deny Jonah's hearing request, issue the permit, and adopt the ED's response to comment. Colleagues?
I'm in agreement.
Also in agreement.
Do I have a motion?
I move that we deny the hearing requests of Jonah Water Special Utility District, issue new TPDES permit number WQ0016229001 to Terrell Timmerman Farms, LP, as recommended by the Executive Director, and adopt the Executive Director's response to comments.
Second.
All those in favor say aye.
Aye.
Aye. Motion passes. Thank y'all. Move on to item 5.
Oh, it was why I brought the jacket.
Financial assurance mechanisms and cost estimates for radioactive material license number R04100 held by Waste Control Specialists LLC. The Executive Director's staff is here to present this item.
Good morning, Commissioners, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I am Chance Gooden with the Radioactive Materials Division. With me today is Don Redmond of the Environmental Law Division. In compliance with 30 Texas Administrative Code, Section 336-736C, Waste Control Specialist financial assurance mechanisms and cost estimates are reviewed annually by the Commission at an open meeting to ensure that the sufficient funds are available for completion of the low-level radioactive waste disposal site closure plan. Included in your backup material is the Radioactive Materials License Financial Assurance Summary for Waste Control Specialists for your review and approval. Thank you for consideration. We'll be happy to answer any questions you may have.
Thank you, Chance. Any questions for Chance?
No questions. I appreciate the review.
Mary, do we have anyone signed up on this item?
No one is signed in on this one.
Garrett?
Good morning, Chairwoman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC supports approval of Waste Control Specialists' financial assurance mechanisms and cost estimates as recommended by the ED.
Short but sweet. Thank you, Garrett. Colleagues, the cost estimates and financial assurance mechanisms we are considering in this matter today include the required increases for inflation. The other elements that would affect closure, post-closure, and corrective action costs that we are to consider, such as changes in amount of disturbed land, changes in engineering plans, and closing or stabilization that has occurred, have not changed since our last consideration. So I'm prepared to move forward with approving the financial assurance mechanisms and cost estimates. Colleagues?
I appreciate that take, Chairwoman. I agree. I acknowledge and appreciate the staff's time and interest on this issue. I know it's a important one of importance not just to Texas, but to Vermont, our interstate compact partner. I want to also acknowledge the importance to the state of Texas stands to grow in the coming years in terms of the coming advanced nuclear interest and activities. The governor just recently designated director of that office, the new action from the legislature. Thank you, Mary. I see you getting uncomfortable that we're getting off topic, but I think this is an important review that our agency does and that will be more important in future years. So it's very worth the time and attention in our agendas now. Thank you.
Good tie-in. Katerina?
I'm in agreement, so I move that we approve Waste Control Specialist financial assurance mechanisms and cost estimates as recommended by the Executive Director.
I second.
All those in favor say aye.
Aye.
Motion passes. Thank y'all very much. We're on our enforcement docket now.
Okay, well, that takes us to the enforcement docket, which are items 6 through 34. Item 16 was previously remanded to the ED. The Executive Director is here to present these matters.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Megan Hamilton of the Enforcement Division, and with me today are Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 6 through 15 and 17 through 34. The total assessed administrative penalties are $783,180, with $52,777 deferred. $230,349 applied towards supplemental environmental projects, and $500,054 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Megan. Mary, do we have anyone signed in on these items?
So on items 9, 11, 13, and 31, we have individuals who are signed in and indicated that they don't wish to speak, but they're available for questions.
Right.
And on 11, we have 2 folks signed in. Would you like to take them?
Yes, we'll take them.
First, we have Catherine Guerra.
She's not here yet.
Second, we have Adrian Shelley.
Good morning, Adrian.
Good morning, Commissioners. Adrian Shelley, Texas Director of Public Citizen. I'm delivering Catherine's comments on her behalf. She's on her way in, but hasn't made it yet. So forgive me, but I'll be reading. Good morning, Commissioners. Speaking on behalf of Catherine Guerra with Public Citizen's Texas office. Public Citizen is a nonprofit consumer advocacy organization that champions the public interest in the halls of power. We have more than 1 million members and supporters across the country. I want to begin by appreciating the Commissioner's comments at the last agenda meeting, especially you, Commissioner Janecka, your openness to the feedback that we provide. We do so because we believe it's the critique of the agency that the public is entitled to. We recognize the limits of this forum, but we welcome additional dialogue with TCQ leadership, both among staff and with commissioners, and we will reach out to invite folks to have additional conversations. Today we're speaking on item 11, the enforcement case against INV. According to the agreed order, INV continued to operate emissions units after their federal operating permit expired in November of 2024. Here we are nearly a year later, INV is still operating without proper authorization. This case highlights a larger systemic problem that commissioners have the power to fix. A facility operating without a valid permit should be shut down until it obtains the required authorization. Yet TCQ's longstanding enforcement practice allows companies to continue to operate, pollute, and profit while enforcement drags on. In effect, the agency's agreed orders grant de facto authority to emit unauthorized pollution, directly contradicting state and federal law requiring permits to construct and operate. We're seeing the consequences of TCQ's outdated enforcement policies today. Just last month, we discussed how leadership historically allowed enforcement cases to sit unresolved for nearly a decade, creating a complex backlog of cases the agency must now navigate. In March, Public Citizen filed a public information request asking TCQ how many agreed orders in the last 3 years have allowed companies to keep operating without a permit, and whether those facilities ever obtained the required authorization. We received no information except for a link to search the database. Even the agency cannot quantify the scale of this issue, or doesn't want to. Nevertheless, Public Citizen is working to quantify it. Commissioners, you all have the ability to examine and correct this policy in a public work session, but nearly every work session scheduled this year has been canceled. Texans deserve regulators who enforce the law, not bend it. We urge you to put this issue on the agenda, open it to discussion, and end the practice of granting unauthorized emissions through agreed orders. Thank you.
Thank you, Adrian.
Chairwoman, I had a question
Absolutely.
for Mr. Shelley. It's my understanding that from our agency's perspective, there's the current operating posture is as legally enforceable. The applicant in this matter is required to continue operating under the terms of that expired permit. My question is, does Public Citizen, through legal intervention, does that legal status pose a different pathway or an obstacle for your organization's use of citizen suits, or the public's use, I will ask?
So the question was, would the use or the availability of a citizen suit to remedy violations be changed by the agency's posture?
How are your tools impacted by that?
Yeah, I think there's a pretty clear argument from somebody who's been, granted this sort of a de facto authorization by the agency that they're not operating outside the bounds of the law, right? If they've been granted a permit, the permit has lapsed, there's a pretty clear argument at that point that they're no longer authorized to operate. But if the agency intervenes, if it initiates a process, and as we know, the agency takes the position that, while an entity is in some kind of an enforcement or a corrective process, it's allowed to continue operating. I think you've got a pretty clear case from the permit holder or the previous permit holder, right, that because they're in an active administrative process with the agency, they're still authorized to operate. So I would say yes, it probably does. It's similar, if I may, to an argument that we made in the past about waivers of pollution laws in disasters, right? We made the argument that those need to be kept as narrow as possible because when there's just sort of an open waiver, the company can very clearly argue, right, that it's operating with sort of a de facto authorization from the agency.
I appreciate that, Mr. Shelley. I have no further questions. From our perspective, our legal tool in engagement with that regulated entity is not impaired. And so I appreciate hearing your perspective on the different touch point that y'all see.
And if I may, just as a practical matter, we talk to people out in the community about this situation and other operations of the agency a lot. And people make analogies to their own lives, right? They say, if I want to build a porch on my front of my house, I need a permit. Or if I want to drive my car, I need a license. And as soon as my driver's license lapses, it's illegal for me to drive the car, right? That's the kind of analogy that people make. That's what they understand. And I think they want industry to be treated in the same way that they're treated. Thank you.
Thank you, Adrian. Garrett?
OPIC has reviewed each of these enforcement items, and with the exception of remanded item 16, we support adoption of all the orders presented by ED staff.
Thank you, Garrett. Thank you always for the presentation and all the work that went into bringing these items to agenda today. For item 13, Formosa, I'm prepared to move forward with this order, but I see that there are some serious violations and a history of noncompliance. In addition, I see that there are 6 additional enforcement items pending, and I am very concerned about what's going on here. I'd like the ED to review the pending enforcement actions for this facility closely, review what is causing these violations, and review the violations with an eye to whether it might not be time to send them over to the Attorney General for enforcement. And to Formosa, I think we need to see some improvements moving forward in operations. This is not acceptable. I reviewed the orders before us, and I'm ready to move forward. Colleagues?
Amen. I agree.
I'm ready to move forward on the orders.
Do I have a motion?
I move that we adopt items 6 through 15 and 17 through 34 as recommended today by the Executive Director.
Second.
All those in favor say aye.
Aye.
Motion passes. Thank y'all.
Item 35 is the consideration of the monthly enforcement report, and the Executive Director staff is here to present this matter as well.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Amy Sedemeyer of the Enforcement Division, and with me are Megan Hamilton of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2025 through July. There were 1,036 effective administrative orders issued, and of those, 94 contain supplemental environmental projects. These orders assessed a total of $12,333,997, with a payable amount of $7,757,607. $2,747,366 are to be paid towards supplemental environmental projects. 17,880 notices of violation have been issued either through our field offices or review of self-reported data in our central office, and 1,679 enforcement action referrals have been received. There are 3,214 pending administrative orders, with 1,300 175 cases that are on the backlog. 131 cases are pending at the Attorney General's office for representation in district court, and 11 judgments have been issued. 1,514 cases are being tracked for compliance. We're available to answer any questions you may have.
Thank you, Amy. Any questions?
I've none.
Garrett?
OPIC has no comment except to say that we appreciate receipt of the report.
Thank you. Thank you for the report. I appreciate the work that OCE is doing to move the enforcement docket. I see a lot of movement. I like it. Colleagues, do you have anything to add?
Second those thoughts, Chairwoman. The final month of that reporting year covered under this report has gone up historically the last couple of years. I still see tremendous progress in terms of the backlog over this calendar year. I'm really proud, really pleased of that ongoing effort. I know a significant amount of the efforts are longer term, and we're continuing to see those paying off, and I'm really grateful to those staff who have taken on what I think is a sincerely harder workload to carry our enforcement and compliance process cradle to grave, rather than having a break that occurred at this juncture. And I hope that the public can appreciate the value added in that process, even though it does add complexity to our workload. Thank you.
Thank you, Bobby. Katarina?
No, but just appreciate the work for Amy and her team. Thank you.
No action is necessary on this one, so let's move to the next items.
Okay, items 36 and 37 are the consideration of the adoption of the amendments to 30 Texas Administrative Code, Chapter 114, subchapters A and C, and the corresponding revisions to the state implementation plan. And the Executive Director's staff is here to present these items.
Oh, sorry. I'll start again. Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Christopher Marino with the Air Quality Division. With me are David Sarins and Allison Stokes with the Air Quality Division, as well as Terry Salem with the Environmental Law Division. For your consideration today is item 36, the Executive Director's revision to 30 Texas Administrative Code, Chapter 114, Control of Air Pollution from Motor Vehicles. Also for your consideration today is item 37, the Executive Director's Vehicle Inspection and Maintenance, or I&M, State Implementation Plan, or SIP, revision. This rule and SIP revision will implement two bills passed during the 88th Texas Legislature 2023 regular session, House Bill 3297, which eliminated the mandatory annual vehicle safety inspection program for non-commercial vehicles, and Senate Bill 2102, which extended the initial registration and inspection period for rental vehicles for 2 years to 3 years. Staff respectfully requests permission to publish the adopted SIP and rule revisions. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you for your consideration. We are available to answer any questions.
Thank you, Christopher. Any questions?
No.
Has anyone signed up on this item?
No one signed in on this one.
Garrett?
Good morning, Chairwoman, Commissioners, General Counsel, and Executive Director. My name is Eli Martinez. I'm Senior Attorney for the Office of Public Interest Counsel, for the record. We've reviewed these items, and OPIC supports the adoption of the proposed amendments to Chapter 114, Subchapters A and C, alongside the concurrent state implementation plan revision. These measures implement House Bill 3297 and Senate Bill 2102 from the 88th Texas Legislature by eliminating outdated safety inspection mandates for non-commercial vehicles and extending initial exemptions for rental vehicles, while ensuring continued protection of air quality in Texas' 18 inspection and maintenance counties. HB 3297 removes the annual safety inspection requirement effective January 1st, 2025, streamlining processes and reducing costs for motorists by $7 per inspection without compromising emissions controls that safeguard public health from ozone and carbon monoxide pollutants. Similarly, SB 2102 allows a 3-year initial registration for rental vehicles, providing flexibility for fleet operators while maintaining emissions exemptions that align with federal Clean Air Act standards. OPIC appreciates the thorough public involvement, including bilingual notices, a virtual hearing on May 29th, 2025, and a comment period that ran through June the 3rd, 2025, which yielded minimal feedback, affirming broad consensus on these practical reforms. These adoptions advance the public interest by balancing regulatory efficiency with environmental safeguards. The rule amendments and SIP revision incorporate cleanup provisions from the 2023 quadrennial rule review, excising obsolete references and thereby enhancing clarity and reducing administrative burdens on inspection stations and the public. Critically, the SIP includes an anti-backsliding demonstration under Clean Air Act, Section 110 sub L, with performance standard modeling confirming no interference with NAAQS attainment or maintenance in areas like Dallas-Fort Worth, Houston, Galveston, Brazoria, Austin, Round Rock, Bexar, and El Paso counties. By shifting low mileage waiver verification to an annual average calculation and integrating safety-related emissions checks, these measures preserve the integrity of the inspection and maintenance program while adapting to legislative intent. For the regulated community, analyzer updates represent routine business, and for Texans, the result is lower costs and fewer barriers to vehicle registration, promoting equitable access without risking air quality degradation. Adopting these measures upholds TCEQ's mandate to protect public health and the environment through modernized, compliant regulations. The absence of significant changes from the May 2nd, 2025 Texas Register proposal, coupled with the minor narrative update in the SIP to clarify rental vehicle exemptions, ensures transparency and fidelity of stakeholder input. And for these reasons, OPIC supports adoption of both measures. Thank you. I'm available for any questions.
Thank you, Eli. First, I'd like to thank staff for their efforts in this rulemaking and SIP revision. This was a big deal. I reviewed both items and believe that the changes to Chapter 114 and the SIP revision will appropriately implement House Bill 3297 and Senate Bill 2102 from the 88th Texas Legislative Session. With that, I'm ready to move forward with adoption.
I agree.
Same. I move that we adopt the amendments to 30 Texas Administrative Code, Chapter 114, and the House Bill 3297 and Senate Bill 2102 Implementation, Inspection, and Maintenance State Implementation Plan Revision as recommended by the Executive Director.
I second.
All those in favor say aye.
Aye.
Aye. Motion passes. Thank you.
Okay. Items 38, the commission will be, that brings us to executive session, and the commission will be meeting in closed session today in room 4222 in Building F at 10:45.
10:50.
10:50, as permitted by Open Meetings Act, including Texas Government Code Sections 551, 071, and 074, to take up and consider matters pursuant to items 38 through 41 as posted and noticed.
Sure. Before we break to recess, can I just ask your indulgence and just steal a moment? I wanted to note that I've completed a 6-year term serving on this commission, and I would really be remiss not to seize the opportunity now, completing my first full month in holdover status, just expressing my appreciation and gratitude to a number of folks. So if you might indulge me, I really would appreciate an opportunity to do so. I really want to first and foremost thank Governor Abbott, his staff, those current and former, sincerely appreciate their support, not just giving me the opportunity to serve in this role, but their ongoing support of this agency and acknowledgement of the value that we bring to this state. I want to thank my wife, Sarah, and my children, Elliot and Malcolm. I think the last 6 years in the role have been a real adventure. Theirs was less fun than mine in a lot of the spots. So I appreciate that. I want to also acknowledge and thank my staff, Farrah Court, Krista Kyle, and Bodie Burks, who's still a member of the family, even though he's not inside of our agency at this time. I really do appreciate sincerely how much they supported the little sub-agency bubble that was Team Janecka, our office within our commissioner agency within the bigger TCQ agency. I've joked in passing, it feels at times we're less an agency and more several agencies and bureaus strapped together in a trench coat. And that brings a lot of really great dialogues and discussions. And I really just want to end and thank my friends across the Capitol agency and state community. I've really been grateful for all of their support in a various number of ways. I also want to thank those people who maybe don't consider themselves my friends. I think that their engagement and our paths crossing over the last 6 years and the entire time I've been working in state government have, by and large, more improved the process than they haven't. And so I want to appreciate and acknowledge the role that they've served as well. Having said all that, thank you very much for that time, and thank you all for the work that we do as a part of an agency I care a whole lot about and I'm really proud of.
I don't know what to say. Let's go to executive session. I'll say everything I need to say there.
Right. I've known you since we were staff together, and it's been great to both be on this journey together, and so really appreciate you.
Thank you.
Sure.
I think this whole agency appreciates your love, dedication, and passion for this agency. I'll say the rest in executive session.
I'm going to divert to a less sad note. Okay, just to get us back into, being less sad. Aubrey has been stepped in for me for special counsel, and she got an opportunity to be the senior attorney for water quality and occupational licensing here at the agency. So she will be departing early while Jesse's out on maternity leave, but I just want to make sure I said thank you to her for her hard work. She's done a great job, and I know that not always easy to deal with, but she's done a great job on it.
Congratulations.
And congratulations, yes.
It's amazing.
She'll be shifting over to October 1st, so y'all get to work with her again.
Wonderful. All right, thank you. With that, this meeting stands in recess. The time is 10:37 a.m.
The commission met in room 4222, Building F, for closed session from 10:57 a.m. until 11:10 a.m. on item numbers 40 through 41, as posted in notice pursuant to the Texas Government Code, Section 551074. No action was taken. This agenda stands adjourned, and the time is, I can't read it on my new phone, 11:20.